Ladies and gentlemen, dear students, it is my great pleasure to address the Conference on International Courts and Tribunals to mark the inauguration of the Center for Public International Law at the Gujarat National Law University. I would like to thank Vice Chancellor Patel for his invitation and this great initiative to promote the increasingly important field of public international law to a new generation of students and soon-to-be lawyers. India is the world's largest democracy and one of the major regional and world powers. And there can be no comprehensive international order and peace without its active involvement. During the Korean War, India provided medical units to the UN intervention. And to this day, I, as every Korean, am deeply grateful to India and other countries that came to serve under the UN flag to protect our freedom. Your conference is a wonderful way to learn more about the role of international courts and tribunals in shaping international law today. I want to use this opportunity to tell you about the International Criminal Court, also known as the ICC, of which I am the president. The ICC is on the cutting edge of the development of international courts. But let us first have a look at the history behind it. The ICC's origins trace back to the aftermath of the Second World War. The horrific crimes committed in the course of the war led to the creation of military tribunals in Nuremberg and Tokyo, which embodied a new recognition that the darkest crimes should be met with fair and public trials. Soon afterwards, however, the progress of international criminal justice was paralyzed by the Cold War and its polarizing effect on the international community for almost 50 years. Then, in the early 1990s, with the newly found consensus among the world's leading powers, the United Nations Security Council took the unprecedented step of creating ad hoc tribunals to try those responsible for the horrible atrocities committed in the former Yugoslavia and Rwanda. Encouraged by the success of the ad hoc tribunals, in 1998, the states decided to create a permanent international criminal court. Gathered in Rome, 120 states adopted the ICC's founding document, the Rome Statute. The mandatory 60 ratifications of the statute followed faster than anyone expected, and within 4 years, the ICC was ready to open its doors. At the same time, in the last 15 years, we have also seen various semi-international or hybrid tribunals created in various places, including East Timor, Sierra Leone, Kosovo, and recently Cambodia. Let me now briefly review some of the ICC's main features. First and foremost, the ICC is a court of last resort. Under the principle of complementarity, the ICC does not replace national courts. It can step in only where a state is unwilling or unable to carry out genuine investigations or prosecutions. This state has to be party to the Rome Statute or the situation has to be referred to the court by the UN Security Council. The court's jurisdiction is also limited to the most serious crimes of concern to the international community as a whole. These crimes include genocide, crimes against humanity, war crimes, and the crime of aggression. However, while a definition of the crime of aggression was adopted by the states parties this year, a new decision after the 1st of January 2017 will be required in order for the court to be able to exercise its jurisdiction over this particular crime. Furthermore, the ICC can only consider crimes committed after the 1st of July 2002. The Rome Statute serves as a safety net for the future, not a mechanism to try past crimes. The ICC's mission is purely judicial. It is not part of the United Nations system or any political organ. The independence of the ICC, its 18 judges, and the prosecutor are protected under the statute. The statute also guarantees fair trials and protection of the rights of the accused. Lastly, the Rome Statute upholds a high standard of victims' participation and protection. The ICC has the power to order reparations such as restitution, compensation, and rehabilitation. The statute is also mindful of the particular interests of victims of violence against women and children. Over the last 8 years, the ICC has become a fully functioning judicial body. The prosecutor has opened 5 investigations in the Democratic Republic of the Congo, Uganda, Central African Republic, Sudan, and Kenya. Of 13 arrest warrants that have been issued, 4 suspects are currently in custody. Our first trial began in January 2009, and the second trial began last November. A third trial may start very soon. While this progress is impressive, there is still work to be done. Many are still rather unfamiliar with the ICC's mandate and activities. Only 15 of 113 states parties to the Rome Statute are from Asia. The lack of knowledge on the court is perhaps the single most significant reason for this major underrepresentation of Asian states. As the first ever Asian president of the ICC, I feel a particular responsibility to increase knowledge of the Rome Statute and the International Criminal Court in this region. In this regard, the emphasis on the Indian and Asian perspective of your conference is highly welcome, and I am encouraged that such an esteemed gathering is taking place. As you may know, India is not yet a state party. Of course, a decision to ratify the Rome Statute is entirely and solely a decision of every sovereign state. Nonetheless, should India decide to ratify the Rome Statute, it would join a global movement of the mentioned 113 states to ensure that the worst crimes known to humanity are not tolerated in the future. By ratifying the Rome Statute, India would also contribute to the ICC's structure and operations by being able to nominate candidates for the judges, the prosecutor, and other elected officials, and having an equal vote in these elections. As students comprising the next generation of lawyers, I hope you will see many of the benefits that the system of the Rome Statute has to offer. Once again, I would like to commend the Center for Public International Law for forging a path for the next generation of international lawyers to pursue studies, research, and training in the exciting field of public international law. I would encourage you to fuel your interest in this field and take full advantage of the resources that the new center will provide. A career in international law is intellectually stimulating, challenging, and very rewarding. When I visited the war-affected communities in the Democratic Republic of the Congo and Uganda, I had a chance to speak personally to some of the victims, many of them with severely mutilated bodies, their arms or legs having been intentionally cut off. Any doubts I may have had about my personal and professional calling were immediately dispelled. Among you, there may well be future staff or even one day judges of the International Criminal Court. Nonetheless, whatever path you choose, I do hope that you will have a rewarding career and that you can say that you have used your law degree to better yourselves and to better humanity. I would like to thank you again for this great opportunity to speak to you today, and I hope you all will learn much from this valuable conference that marks a truly momentous occasion for your esteemed university.